Get off to the side here.
Somebody's trying to kill me.
Get on the street.
Somebody's trying to kill me.
Hey, stop right there.
Yes. Oh my God.
Possible DUI driver. I get additional witness, please.
The car.
Okay, what happened?
I lost my key.
You lost your key?
Yes. I came and I had somebody fix my car for me, sir.
Sit with your legs crossed. Sit with your legs crossed.
They're gonna try to kill me, please.
Who's trying to kill you?
I had a stunt today. They're gonna try to put stuff in my car.
Who's trying to put stuff in your car?
They're gonna try to.
So, who's trying to get you? You said somebody's trying to kill you?
No, sir, nobody's trying to kill my car job.
What's that?
My car malfunction.
Who's trying to kill you?
My car malfunction.
Your car malfunction?
Yes, sir.
What's your name?
Keenan Anderson. Please look at that, sir. Look.
What?
Help! Help!
What do you need help with, sir?
Help, please!
I'm here helping you, alright?
Please help me! Help!
I'm here
Help,
helping you.
please!
I'm here helping
No,
you.
I'm not okay, ma'am. I'm not okay, ma'am. Please.
Just keep the...
Please.
Hey, keep sitting down. Keep sitting down.
Please.
Stay down for me. Hey.
Please.
Hey, stay
Please.
here. Stay here.
Sir, I need
Stay
some water.
here.
Can you get some water? Please.
Stay here. I'll get you some water here in a second, okay?
Please.
Just have a seat up against the wall there,
Yes, sir.
okay? If you want to be seen,
I don't
stay
wanna
right
sit
there.
No, I don't want to sit right there.
Stay right there if you want to have somebody see you.
Please. Please.
Come here.
Please. Please.
Come here. Get down over there. Turn over on your stomach right now. Turn over.
Please don't do this, sir. Please. Help me. Please. Help me. Help me, please. Please. Please.
Welcome to episode 15 of the Force Review. I'll be your host for the next few minutes. I'm an active patrol cop with 13 years of experience. Let's get to it. This episode is going to cover a controversial incident involving the LAPD. Keenan Anderson was taken into custody at the scene of a traffic collision. Officers used a taser to accomplish this task, and Mr. Anderson died 4.5 hours later at the hospital. The LAPD later released a statement saying Mr. Anderson's blood tested positive for cocaine metabolite and cannabinoids. Mr. Anderson's family has hired a couple lawyers for a $50 million lawsuit. Here's what attorney Carl Douglas had to say.
In this case, it is certainly clear that a substantial factor causing Mr. Anderson's death was not the presence of any drugs in his system, but it was the decision by trained killers to taser Mr. Anderson at least 6 times.
Attorney Ben Crump is also representing the family. Here's what he had to say.
Then Keenan Anderson was correct. They George Floyd him.
Several citizens also voiced their outrage at a recent LA City Council meeting.
Keenan Anderson, say his name! Say his name! Say his name! We demand that cops be pulled out of everything that is not, out of everything, point blank period. But let's make sure that we start with traffic stops and mental health crises.
Shame on you. Keenan Anderson was murdered in your district. Shame on you.
And maybe had you listened when I said that we should not allow, we need to ban travel to Los Angeles until we can control these murderous cops, maybe he would still be alive.
We need police accountability. It's unacceptable that we are still seeing people murdered by police.
Keenan was no threat to any of the officers that were there that day.
Your rhetoric allowed for the killing of my cousin.
So what's the truth? Maybe this guy knows.
We're here for Keenan Anderson, who was murdered by the police, who was having a mental health crisis, who police attacked, tased, which caused him to go into cardiac arrest.
Justin seems like he's got his mind made up. He must have done a thorough analysis of the body cam footage, researched statutes, and applied relevant case law.
I don't need to, I didn't see all the video. I have no desire to see all the video.
Okay, maybe Justin didn't exactly do his homework, but at least watch the video before you call someone a murderer. Come on, Justin. Okay, here we go. January 3rd, 2023, Los Angeles, California. Keenan Anderson is involved in a traffic collision. According to LAPD Chief Michael Moore, the collision involved at least one injury and Mr. Anderson caused the collision. Officer 1 is in the area and happens to come across the scene.
Where are you at? The driver? Get off to the side here.
Somebody's trying to kill
Get
me.
on the street.
Somebody's trying to kill me.
Hey, stop right there.
Yes.
Get up against the wall.
I'm sorry, I didn't mean to.
Get up against the wall.
Please, sir, I didn't mean to.
Get up against the wall.
I didn't
Get
mean
up against the wall real quick.
Please.
Okay,
Please,
hold on
God.
a second.
Please,
Hold on
sir,
a
I didn't
second.
mean to, sir, please.
Hold on,
Please.
okay?
I'm sorry.
Mary 156, show me code 6 on a TC not involved.
Please.
We're gonna be Venice, west of Lincoln.
Oh my God.
Possible DUI driver. I get additional units, please.
So right now, Officer 1 is detaining Mr. Anderson for driving under the influence and causing an injury collision, a felony. Mr. Anderson is required by law to follow this officer's orders.
The car.
Okay, what happened?
I lost my key.
You lost your key?
Yes. I came and I had somebody fix my car for me, sir. Please, don't, please,
okay,
sir.
do me a favor, sit in
please.
Hey,
Sir, please.
sit down on your butt and sit with your legs crossed. Sit
Somebody
with your legs
trying to
crossed.
kill me, sir.
Sit with your legs
Please.
crossed.
They're gonna try to kill me, please.
Who's trying to kill you?
I had a stunt today.
What?
I had a stunt today, sir.
You
I
had
didn't mean to.
you had what?
A stunt. Like, no, that's a car.
Okay, what car were you driving?
BMW.
The BMW.
They're gonna try to put stuff in my car.
Who's trying to put stuff in your car?
They're gonna try to. I'm sorry. Nobody.
So 7 Mary 156. I'm gonna be with
Please don't, please, sir. Please, please. Sir,
the
please.
coffee shop on the northwest direction, northeast corner.
She said my name's coffee, says. Please. Please, sir, please. Please.
Okay. Do you have an ID in your pocket at all?
No, sir.
No ID on you. Are you gonna have an ID in the car?
Yes, sir.
Okay.
Please.
So who's trying to get you? You said somebody's trying to kill you?
No, sir. Nobody's trying to kill my car job.
What's that?
My car malfunction.
Who's trying to kill you?
My car malfunction.
Your car malfunction.
Yes, sir.
Okay.
So we can see that Mr. Anderson is acting very strange. It's clear that he's either under the influence of narcotics or having a mental health episode. We're going to fast forward through some of this because Officer 1 just talks to Mr. Anderson for about 6 minutes while waiting for backup. You can watch the entire unedited video on our other channel, TFR Uncut. While Officer 1 is talking to Mr. Anderson, he requests an ambulance.
Come here, I don't want you in the road. Come here.
Please.
Come here.
Please.
Come here.
Please. Please.
Come here. Turn over on your stomach right now! Turn over on your stomach right now! Turn over!
Yes.
Turn over!
Yes, sir.
Over on your stomach! Get over on your stomach!
Hold on. Okay, please. Please, sir, please don't do this. Please don't do this, sir. Please! Help me, please! You know what? Help me, please! No, please, help me! Help me, please! Please!
Keenan, relax! Keenan, relax!
Help! They're trying to kill me! Stop, I'm gonna take you!
Officers 2 and 3 arrive on scene as Mr. Anderson begins running away from Officer 1.
We already have a unit helping you guys out, right? So give us a second. We're going to try to set everything up so that way no one gets hit and there's no other vehicles.
I think the guy up there needs help though, because the guy's trying to run away. The guy who's driving this car.
Let's go get him.
American 156 coming.
Turn around.
Turn over! Over on your stomach! Get over on your stomach!
Hold on!
Get down.
Please.
Get down.
Please, sir, please don't do this! Please don't do this, sir! Please! Help me, please! You know what? Help me, please! No, please help me! Help me, please! 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 Keenan, relax! Please! Watch out. Watch out! Help! They're trying to kill me! Hey, stop! I'm gonna tase you! Stop! I'm gonna tase you! Relo's trying to kill me! I had it stuck on YouTube! Stop it or I'm gonna tase you! Yes, sir! Stop it or I'm gonna tase you! Hey, please help me! Help! Help! Stop it or I'm gonna tase you! Stop it or I'm gonna tase you! I'm gonna tase you! Stop it right now! Stop it right now! Turn over! Turn over or I'm gonna tase you! Turn over or I'm gonna tase you! Turn over or I'm gonna tase you! Yes! Watch your elbow, partner. You're trying to George Floyd me. You're trying to George Floyd me. Stop it or I'm gonna tase you. Okay, stop it or I'm gonna tase you. Stop it or I'm gonna tase you. Stop resisting. Please. Stop resisting. Please. I'm gonna tase him. I'm gonna tase him. They're trying to kill me. Stop it.
Officer 2 tases Mr. Anderson. Was this use of the taser legal? To answer that question, we're going to do a quick review on the legal evolution of police use of force. The Fourth Amendment of the Constitution says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." A police officer making an arrest is seizing that person. A police officer using excessive force to make an arrest is making an unreasonable seizure, a violation of the Fourth Amendment. So what constitutes an unreasonable seizure? While some cases are obvious, such as Officer Brennan's unreasonable seizure of Eric Cantu in Episode 11, there are many cases, such as the seizure of Jalen Walker in Episode 5, which fall into a tougher gray area. The gray area is clarified by the courts using case law. The courts review specific cases in which police officers are accused of Fourth Amendment violations. If the court deems the officer used excessive force in a specific situation, they will publish their opinion, and this opinion will become law. In this way, the rules for using force to make an arrest become more clearly defined with every case reviewed by the courts. For example, in 1974, Memphis police officer Elton Hyman responded to a burglary in progress. During the incident, he observed Edward Garner fleeing the scene. Officer Hyman ordered Mr. Garner to stop, but Mr. Garner ignored him and kept running. Officer Hyman shot Mr. Garner in the back of the head to prevent Mr. Garner's escape and to make the arrest. Officer Hyman was guided by Tennessee law, which stated, if after notice of intention to arrest the defendant, he either flee or forcibly resist, the officer may use all the necessary means to effect the arrest. The case went all the way to the United States Supreme Court. The court determined that Officer Hyman's seizure of Mr. Garner was unreasonable. However, Tennessee law at the time stated that a police officer could use any means necessary to stop a fleeing felon. The Supreme Court determined Tennessee's fleeing felon law unconstitutional. They also more clearly defined when an officer could shoot a fleeing felon. They said, where the officer has probable cause to believe that the suspect poses a threat of serious physical harm, either to the officer or others, it is not constitutionally unreasonable to prevent escape by using deadly force. Thus, if the suspect threatens the officer with a weapon, or there is probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used if necessary to prevent escape, and if, where feasible, some warning has been given. In this way, the court more clearly defined the unreasonable seizure mentioned in the Fourth Amendment. However, since the definition of an unreasonable seizure was not clear as applied to the situation confronted by Officer Hyman, he was given immunity from civil liability. However, now that the law has been more clearly defined, police officers have been put on notice that a future action similar to Officer Hyman's will be deemed unconstitutional. The original case governing police use of force was Graham v. Conner in 1989. This case laid down 3 factors police must consider when using force to make an arrest. Number 1, the severity of the crime. Number 2, whether the suspect poses an immediate threat to the safety of the officers or others. Number 3, whether he is actively resisting arrest or attempting to evade arrest by flight. Since Graham was a U.S. Supreme Court case, all police uses of force must be judged using its direction. So let's apply the 3 principles from Graham to the seizure of Keenan Anderson so far. Number 1, severity of the crime. Mr. Anderson's crimes so far include driving under the influence causing injury, a felony, and hit and run with injury, another felony. Number 2, immediacy of the threat. Does Mr. Anderson pose an immediate threat to the officers? This question is a little tougher to answer, but yes, Mr. Anderson does pose some threat to them. First of all, he is fighting with them in the middle of a busy street. Second, Mr. Anderson doesn't just resist their efforts to subdue him, but he also grabs at the officers here. He also flails his arms at them here, and grabs an officer's hand again here. As for our third gram factor, whether Mr. Anderson is actively resisting arrest or attempting to evade arrest by flight, the answer is obviously yes. Okay, so were those factors enough for the officer to tase Mr. Anderson? Before we answer that, let's get some more context. Let's take a look at 3 more cases that help clarify Graham in this specific situation. In Bryan v. McPherson, Officer McPherson stopped Carl Bryan for a seatbelt violation. Mr. Bryan stepped out of the car, yelled gibberish, and smacked his thighs in anger. Officer McPherson tased Mr. Bryan. The U.S. Court of Appeals 9th Circuit made a few important statements. They said, tasers like the X26 constitute an intermediate or medium, though not insignificant, quantum of force. And a desire to resolve quickly a potentially dangerous situation is not the type of governmental interest that, standing alone, justifies the use of force that may cause serious injury. Rather, the objective facts must indicate that the suspect poses an immediate threat to the officer or a member of the public. Ultimately, the 9th Circuit ruled the tasing of Mr. Bryan unconstitutional. However, the officer was given qualified immunity because the law in his situation hadn't been clearly defined at that point. Seattle, Washington, 2004. Malika Brooks is pulled over for speeding. She refuses to sign the ticket and the officers decide to arrest her. She refused to step out of the vehicle and submit to arrest. When the officers attempt to extract her by force, she tenses up, gripping the steering wheel and refusing to move. The officers tase her 3 times before they are successful in extracting her from the vehicle. Ms. Brooks sued the officers and the case was reviewed by the 9th Circuit Court of Appeals. The court ruled the tasing unconstitutional. In Brooks, the court concluded that Ms. Brooks resisted arrest, but did not pose an immediate threat to the officers. Thus, the tasing was not justified. 2011, Village of Pinehurst, North Carolina. A doctor has issued a mental health hold on Ronald Armstrong because he is a danger to himself. Officers attempt to take Mr. Armstrong into custody, but Mr. Armstrong wraps his arms around a stop sign, refusing to budge. Officer Gatling tases Mr. Armstrong 5 times over the course of 2 minutes. The officers eventually get help by hospital staff to subdue Mr. Armstrong in handcuffs. Almost as soon as they do handcuff him, he dies. The 4th Circuit Court of Appeals found the tasing unconstitutional. The court stated, tasers are proportional force only when deployed in response to a situation in which a reasonable officer would perceive some immediate danger that could be mitigated by using the taser. In light of Mr. Anderson's behavior up to this point to include committing a felony crime, running from the police, grabbing the officer's arms and hands while they tried to detain him, thrashing his arms at them, and resisting their attempts to restrain him, I've determined that this first tasing was constitutional. Speaking of that first taser application, let's take a closer look at it.
I'm a taser. I'm a taser. They're trying to kill me. They're trying to kill me.
Did you hear the change in the pitch of the taser? That happened because one of the probes fell out. When that happened, the officer switched to drive stun mode.
Stop it.
So for the purposes of this video, I'm going to count that combination of probe deployment and drive stun as the first taser application. Okay, so the first tasing was constitutional, but we still have 4 more to go because every use of the taser must be evaluated on its own. Just because Mr. Anderson's behavior qualified for one tasing, that doesn't mean the officers can keep on tasing him again and again. If the situation changes, they must reevaluate. Let's switch to another officer's view for the second taser application.
Help! Stop it. Yes.
The second taser application was constitutional because Mr. Anderson was still resisting and his right arm was not secure. Let's check out the third tasing.
Stop it.
Yes, sir.
Don't resist.
No.
Stop
Okay.
it. Stop resisting.
Okay.
Mr. Anderson's right arm is still not secure, so the third tasing was fine. Here's the fourth taser application.
Stop it.
Help.
Stop
Help,
it.
please. Help.
Do not move. Just get another car.
Same thing. His right arm still isn't secure and he's still resisting. Here's the fifth and final tasing.
America, do not move. If not, I'm gonna tase you again. Okay, I got one.
Help me. Okay.
Here, hold on. Stop it. Stop resisting. Stop resisting.
Here's his right arm at the start of the 5th tasing. The arm looks to be behind Mr. Anderson's back. Let's check out the other officer's view.
Stop it. Stop resisting.
It looks like both Mr. Anderson's arms are behind his back and he's being pinned down. In the case Meyers v. Baltimore County, the 4th Circuit Court of Appeals noted, "It is an excessive and unreasonable use of force for a police officer repeatedly to administer electrical shocks with a taser on an individual who is no longer armed, has been brought to the ground, has been restrained physically by several other officers, and no longer is actively resisting arrest." There is one factor in Mr. Anderson's case that distinguishes his situation from the quote from the 4th Circuit. Mr. Anderson is still resisting. However, the 9th Circuit, the court which has jurisdiction over Los Angeles, has said at least twice that the taser is for a subject who poses an immediate threat. It is hard to make the case that Mr. Anderson was an immediate threat to the officers once he had been pinned down and his hands were behind his back. So with the combination of the case law of Brooks, McPherson, and Meyers, it is likely that the 5th tasing will be held unconstitutional. However, since it's a close call and there are some factors in this case which don't appear in the others, the officer may get qualified immunity. Okay, so the 5th tasing was unconstitutional. Does that mean that the officer will be charged and convicted? Let's take a look at some of the charges that may apply. We have murder, voluntary manslaughter, and involuntary manslaughter. The chance of conviction for any of these charges is pretty much 0. A huge factor in this situation is that Mr. Anderson died 4.5 hours after the tasing. Here he is still alive 12 minutes after the 5th taser application. So in order for any murder or manslaughter charges to stick, the prosecutor would have to prove that Mr. Anderson died from the taser. That means they would have to disprove that he died from the car crash, the cocaine in his system, and any drugs given to him by medical staff. This is simply not going to happen. How about assault with a deadly weapon? That's not going to work either. The officer used the taser in an approved manner, not in a manner which would likely have resulted in serious injury. How about battery? This is the only charge with any hope of sticking. However, a conviction for battery in this situation is about 0 as well. Clearly, the officer had no malice towards Mr. Anderson. Therefore, the force review predicts no conviction for the officer in this case. I believe the officer's error on the 5th tasing was a combination of being involved in a rapidly evolving situation, plus the idiosyncrasies of case law which make it hard enough to interpret for lawyers, let alone police officers involved in a scuffle. So what are the lessons learned from this situation? Number 1. Tasers are not for taking a suspect into custody. They are for mitigating an immediate threat. Number 2. Proficiency in grappling is an officer's best tool for taking a suspect into custody. Number 3. Don't use cocaine. You don't know how your brain will react to it. Clearly, Mr. Anderson was not in his right mind during this situation. That is it for episode 15 of the Force Review. If you want to watch the entire unedited video from this incident, check out our other channel, TFR Uncut. Please subscribe, and we will see you on the next one.